We're now going to move on and look at public law and private law. The aim here is to create a stable and law-abiding society. Let's have a look first of all at the difference between public law and private law. Public law governs relationships between individuals and the state. Public law deals with matters relating to the whole country. For example, if the government passed a law that made an action illegal, this would affect everybody in the country. Private law is very different. This deals with relationships between individuals that are not a matter for the whole country. We have an example here, a dispute between two individuals over whether a contract has been properly performed. This would be a matter for private law, as it doesn't affect the wider public. Moving on, we can look at criminal law and civil law, and you need to be aware of the differences between the two for your examination. So these are the two main branches of law in the UK that affect us and as individuals. They have different types of trials and different punishments. Criminal law is a form of public law, which we saw above. It relates to conduct that the state wants to control. So criminal law would prevent any negative effects on society as a whole. Examples here might be armed robbery, theft, burglary, traffic offences, fraud, assault, murder or manslaughter. Civil law is a form of private law, which again we saw at the top of the page here. It's used to settle disputes between individuals. As accountants, you're more likely to come across civil law, hopefully, I would think so, in your working lives. It's where one person commits an offence which is harmful towards another person's rights or property. And it also covers individuals and organisations. So examples here would be employment tribunals, breaches of contract, and personal injury. Here we have a great table highlighting the key differences. With civil law over on the right hand side, remember this is private law. And this is where there are differences and disputes between people. Let's think of an example. Let's say that I move house and this house is in need of a bit of renovation. It needs some rewiring. So I call in an electrician. I need new sockets and some new wiring, etc. My electrician doesn't do a good enough job. He's not performed what was agreed in the first instance, and the work may even be dangerous. We're the only people interested in the dispute. It's not a nationwide matter, so it's a private law, it's civil law. It's me and the electrician. If we can't agree a way forward, we need to consider where we would go. Well, we would go to the courts. And I would initiate this as the claimant. Most civil cases start in county court. A few start in a magistrate's court, but this is very rare. So for exam purposes, it's county court. In terms of the terminology that would be used, this is a civil case. it's private law. I am the claimant, and let's say I have used Bob the builder, Bob the electrician, who is the defendant. The claimant would be my last name Coleman, and the defendant would be Bob the builder. So this would be written Coleman versus Bob, and that would be the name of the case. The aim of the case would be to establish if Bob the builder, the defendant, is liable or not liable. And the court will try to decide on the relevant outcome. The aim is to achieve compensation for me. He's not done the job properly. I have dangerous electrical wiring in my house, so I want money in the form of compensation. I'm the injured party, I have the dangerous house, and I want compensation. Now, in terms of the level of proof needed, here it's on a balance of probabilities. So think of a set of scales. They want to just tip them in my favour, or they could be slightly tipped in Bob's favour, and it would be up to the judge to decide based on the facts of the case. So if Bob is liable, he'll pay me damages to rectify the issues. Other things could happen. We could require specific performance, which we mentioned in the previous recording, making Bob do something, making him rectify the damage or to finish off the job. Or there could be an injunction, stopping someone from doing something. It could be settled out of court. Think about big celebrities claiming against newspapers for violation of privacy. That could be an out of court settlement. And the main reason for doing that would be so that details are not in the public domain, which is obviously very important for celebrities. So the aim with civil law is to set right an unfair situation. Let's now look at criminal law, also known as public law. And this is the more exciting stuff. Think about television programs and the big cases you see on television. Criminal law here might be that there has been a big theft or a burglary. And in this situation, it's not just me who's interested, like with our civil law. This is actually in the public interest and has an impact on the public. Crimes have been committed that are prohibited by law, so it's not good for the state. Where these happen, they all start in the magistrate's court. It can go on to somewhere else, but we start in the magistrate's court. And we have the prosecution and we have the defendant. The name here would be R versus, perhaps if I'm being prosecuted, Coleman. R stands for Regina, the Crown, the state against Nicola Coleman. What we're looking for here is whether the party is guilty or not guilty. What we're looking to do is to punish the wrongdoer. And this should be beyond reasonable doubt. Because things are very serious here, there's a much higher burden of proof that's needed. The court must determine that they are guilty beyond reasonable doubt. No out of court settlements. Because what we're doing here is we're going to take away somebody's liberty. We're going to put them in prison, and that's very serious. So we have to be pretty certain before locking them up. The aim of criminal law is to punish the offender in a way to prevent them doing it again. Welcome back. Having viewed the recording on public law and private law, and criminal law and civil law, we're now going to try and apply our knowledge to a couple of lecture examples. So let's start with lecture example 2, which is all about criminal and civil law. If you need to, please refer back to the previous recording. There was a very handy table that we had where we broke down criminal law and civil law and the various characteristics. So the question we need to try and answer here is which of the following is not a characteristic of civil law? And you do need to be very careful in your examination, reading the question very properly and very well under the time pressures that you have on you. So this one is about which one is not a characteristic of civil law, which one is not a characteristic of private law. And if we remember correctly, back to our table, looking at civil law, looking at private law, this is differences and disagreements between individuals. Okay, so the first one here, the case is brought by the state. And this one is actually our correct answer, the first one we're looking at. This is criminal law, public law. It's regarding the conduct of something that the state wants to control. The second one here, the purpose is compensation of the victim. The victim is the claimant. And this is actually a feature of civil law. So incorrect in this question, it is not a characteristic of civil law. The third one here, if the defendant loses, it's likely to result in an award of damages. Now, damages are civil law. So this is not the correct answer to the question. For criminal law, it's a fine and or imprisonment. And the final one here, the standard proof is balance of probabilities. Well, remembering back to our table, a balance of probabilities is in civil law, in private law. With criminal law and public law, we're having to prove beyond reasonable doubt. So here, with the balance of probabilities, think about our scales tipping one way or another way. Let's move on and have a look at lecture example 3. Ed stole a valuable watch from Emma's home. This matter has been brought before the courts. What we need to answer here is which of the following applies. So, stealing, theft, this is something that the state do not want to encourage. So, this is a criminal case. This is a criminal case, it's public law. Stealing should not be encouraged. So automatically we can see that the answer here could either be criminal case here in answer 1 or a criminal case in number 3. So we can automatically rule out numbers 2 and 4. So let's look at more detail. Part 1, this is a criminal case. That's correct. It's a public law concerning a matter of private law. Well, Yes, it's criminal case, but it's not private law, so this rules out answer number 1. The correct answer is therefore number 3. It is a criminal case, tick, concerning a matter of public law, tick. Burglary is a crime that has implications for everybody in society. In part B here, they're asking us what will be the burden of proof in this case. So what happens? What could the outcome be? And with a criminal case in public law, guilt has got to be shown beyond all reasonable doubt. So we can spot these in answer 2 and in answer 4. So we can rule out answers 1 and 3 in this situation. In number 2, the claimant must prove beyond reasonable doubt that Ed stole the watch. This isn't correct. It's actually the prosecution who need to prove. So number 2 is incorrect. And number 4 is correct. The prosecution have to prove beyond reasonable doubt that Ed stole the watch. It's the correct terminology and the standard of proof for a criminal case. In our part C here, which 2 of the following outcomes are possible here? Once again, read the question properly. We need to tick 2 correct answers. And remember, we're looking at criminal law in this lecture example 3. So the first one here, the court will grant an injunction. And remember, back to our nice table that we had, this is actually an outcome of civil law. Ed will be ordered to pay damages. This one is also civil law or private law. Ed will be ordered to pay a fine. This would be correct under criminal law. And remember, we need 2 answers. So the other correct answer is our 4th one, and Ed could be imprisoned under criminal law. So 2 correct answers there. Okay, let's now go into more detail about the different types of courts that there are in the UK. There is a hierarchy of courts in the English legal system, and this is very much like a hierarchy that we saw in a previous recording when we're looking at an organisation. With an organisation, we have the board of directors at the top, we have our middle management in the middle, and at the bottom of the hierarchy, we have our day-to-day operational staff. So, very similar with the courts, we have a hierarchy, an order that we go through. Now, it does depend if it's a criminal case or if it is a civil case. And it says in the notes here that most criminal cases will begin in the magistrates' court. Now, you as accountants, I would imagine, are more likely to see civil cases, and these begin in the county court or a division of the High Court. Let's look at a little bit more detail about our county courts or the High Courts. So the first one, as the notes mentioned, most civil cases start in our county court. And this is known as the Court of First Instance. It's the first place we go to if we have a problem between individuals in a civil case. It's a small claims court, usually up to £10,000. And the benefits of this one is that it is relatively quick, it's more informal, and it's often cheaper. Or we could see a civil case in a division of the High Court. And the High Court deals with more complex cases. Or perhaps if bad decisions were made at the county court, then they can appeal to the High Court. Now, we've mentioned various different divisions of the High Court. There are three. There are three divisions or three specialisms. The first one is known as the Queen's Bench Division. Probably a little bit too much detail here for your examination, but it's quite interesting. This one here deals with contract and tort, which we'll see at a later date. But we can remember this one, remembering B, Queen's Bench Division, B for business. So this deals with civil cases regarding businesses. The second division is called the Chancery Division. And this one is all about dealing with partnerships, disagreements with partnerships, and companies as well. And we can remember this one with the C, Chancery Division for companies. And the third one is the Family Division. Nice and easy to remember. Family, all to do with families, divorce, etc. So, as accountants, you are more likely to see things either being disputed in the Queen's Bench Division within the High Court or the Chancery Division regarding partnerships and companies. So we mentioned the idea of appeals and appeals going to a particular division of the High Court if they're not satisfied within the county court. And we have a bit of information here in our notes regarding appeals. Appeals can be made to the higher court, such as the Court of Appeal or the Supreme Court. So the Court of Appeal, first of all, is where there are three judges. Or if you're really, really not happy, you might take it to the Supreme Court. This is the highest UK court, and there are 5 judges here. They're known as the Justices of the Supreme Court. Now, these are actually known as the Appellate Courts. The Supreme Court is known as the Appellate Court. They only hear appeals. They cannot start proceedings in the Supreme Court. When applying judicial precedent as a general rule, the precedents of higher courts bind the lower courts, but not vice versa. So those higher courts, those ones at the top, do bind those courts that are lower down, but not vice versa. And the aim here is that decisions are made that are consistent with previous judges. Now, we may not want to go to court. We may have something called a tribunal instead. And tribunals form part of the English legal system, and they're used as an alternative to the court system. There are many tribunals covering a wide range of areas affecting day-to-day life. One example might be an employment tribunal, which settles disputes between perhaps you and your employer. And we'll see a few benefits and drawbacks in a moment. Other tribunals might be Immigration Tribunal, Social Security Tribunal, Pension Tribunal. And another is the first tier tax tribunal that actually handles appeals against HMRC decisions. So some are administered through local authorities and others are managed through Her Majesty's Courts and Tribunals Service, which is known as HMCTS. Let's have a look at a few advantages of tribunals and a few drawbacks, disadvantages of tribunals. Cases will be heard by someone who is an expert in that area of law, so they know the ins and outs of a particular area of law. A benefit is that it can be cheaper. It is less formal and less intimidating than the courts, but the main benefit I would say is that it is often quicker than using the courts. If you want to get something resolved, perhaps at work, then you would go to a tribunal rather than waiting years for a court date. The drawbacks of tribunals are that judicial precedents do not apply, so outcomes could be inconsistent. And also linked to the idea of it being cheaper, unfortunately, legal aid is not available in tribunals. Hi, welcome back. Having looked at the hierarchy of courts in the English legal system and also tribunals, we're now going to look at the main sources of law. And you can see from the notes here that our laws come from two main sources. The first is case law. And with case law, this is where judges make a decision, and this sets what we call a legal precedent that we saw in an earlier recording. This is known as judge-made law. Our second main source is legislation, and this is where Parliament will pass a law. So this is known as Parliament-made law. So, regarding legislation, if it's created by acts of Parliament, for example, the Companies Act would be one of them. The law is called primary legislation. It's the primary lawmaker. So let's have a look at what Parliament can do. They can repeal earlier legislation. They can call it back. And this would be where earlier statute is invalidated by a later one. They can also overrule case law. It's a bit like a hierarchy. Our primary legislation will overrule case law. And that's a good thing. After all, with Parliament, we've elected them and they have democratic accountability. Finally, they can make new laws. They can pass new laws. An important thing to remember here is that courts cannot overrule primary legislation. Remember, there is that hierarchy. So, over the page, let's have a look at parliamentary procedure for actually bringing in these new laws. It says here that the government itself, an individual MP, or a member of the House of Lords can introduce legislation. So there's three different ways that legislation can be introduced? Legislation can be introduced either in the House of Commons or in the House of Lords. An important thing to remember is that if a law is passed through one house, the procedure is repeated in the other house. So ultimately, it goes through both. Let's annotate this on our table. So, our first reading through to royal assent here, through the Commons and the House of Lords. Okay, so the bill goes through the following stages. The bill is draft legislation. The bill goes through the following stages. So we have a first reading, and this is simply where the bill is introduced to the House, and there's no debate here, no discussion. It's simply, here is the bill. Next time we'll be looking at this. In the second reading, this is where they debate the general merits of the bill and they vote to continue or kill the process. So they're asking ourselves, is it a good idea? Yes or no? So if they kill it, no, it's not a good idea, it stops here. And it's said that government are defeated. If they vote yes, then we go to the committee stage. This is where they open the bill, they read the detail clause by clause and line by line. And this is by a committee of MPs. So, not the whole of Parliament, but various committees. And these committees will have various expertise or special interest. For example, it could be the Education Committee. For very important legislation, in an exception, the whole House may constitute the committee. We then move to the report stage, and this is where the amended bill is reported back to the House to consider any amendments. So, any changes are done here. And this is where the bill goes from the committee back to the House of Commons or Lords. We then have the third reading, and the amended bill is voted on by the House. So, this is where they're saying, as it now stands, what do you think? And if it's then passed, the bill passes to the other House. So, if it's been through the House of Commons, it goes to the House of Lords, and vice versa. And it's here that the bill becomes an act. It's now an act of Parliament. To finish off the recording, let's have a look at a couple of lecture examples, starting with lecture example 4. Select whether the following statements are true or false. So, the first one here is that case law takes precedence over legislation. And here we need to remember our hierarchy that we saw on the previous page. So, what have we got here? Let's have a look. Legislation actually takes precedent over case law. So this would be false. It's known as primary legislation. So legislation first. The second one here is that equity prevails over common law. So we need an awareness here of what each of them are. Well, common law, to rectify, it's just damages. It's in the form of money. And the aim with that one is consistency and certainty. It can be harsh, it can be inflexible. It was set a very long time ago. So, equity was introduced. It's known as being the gloss on the top of common law rules to actually improve common law. And the aim with this one was fairness and morality. Equity prevails, it's more fair. Examples are of equity resolution would be specific performance, injunctions, and rescission. Finally, we have lecture example 5, sources of law. We need to match the following sources of law with their definitions. So we have case law to start with. And case law is set by judges. So we're going to match that one to the bottom one. Laws created by the previous decision of a judge. It's judge-made law. And we have legal precedents. And the next one, legislation, of course, has to match to the first one here, the first option, laws set by Acts of Parliament. And this is our Parliament-made law. That brings us to the end of the recording.